Friends, today's subject of study is the right of accused person. To start with, while making a study of the right of an accused person regarding arrest and detention, the term accused person requires to be ascertained. The term is not defined in the criminal law and criminal procedure, although the term is mentioned elsewhere in some law books. Under Article 20, Clause 3 of the Constitution of India, provisions have been made for the benefit of accused persons. It is provided that an accused cannot be compelled to be a witness against himself. In this connection, an accused is a person on trial for an allegation against him for committing a crime, that is, an act or omission that is made punishable by law. Under Section 24 of the Indian Evidence Act 1872, the expression "a person accused of an offence" is used to mean a person against whom evidence is sought to be laid in a criminal proceeding. When evidence, whether oral or circumstantial, points a person to be guilty, and such person is taken to the custody and interrogated on that basis, he becomes a person accused of an offence. Certain rights arise even though he is an accused person. To mention such rights are the rights guaranteed under the national and international law, and the rights guaranteed under the law of evidence and criminal procedure of the land, which require to make elaboration. The Universal Declaration of Human Rights, 1948, was adopted and proclaimed by the General Assembly of the United Nations on the 10th of December, 1948. Everyone is entitled to all rights and freedoms set forth in that declaration without distinction of any kind, such as status. Article 9 of the Declaration provides that no one shall be subjected to arbitrary arrest, detention, or exile. Under Article 10 of the Declaration, everyone is entitled to a fair public hearing by an independent and impartial tribunal in the determination of his rights and for any criminal charges against him. Under Article 11, everyone charged with a penal offence has the right to be presumed innocent until proved guilty by law in a public trial. No one can be held guilty for an offence under which did not constitute an offence by the national or international law at a time when it was committed. So these are the provisions that are laid down in the Universal Declaration of Human Rights. The Constitution of India has incorporated these human rights of accused person and enacted in Part 3 in the form of fundamental rights. Article 20 of the Constitution guarantees protection to be afforded to the accused persons. Article 20, Clause 3 lays down that no person accused of an offence shall be compelled to be a witness against himself. The implication of the article is that an accused person cannot be compelled to furnish any kind of evidence which is reasonably likely to support a prosecution against him. Article 20, Clause 1 prohibit retrospective criminal legislation, commonly known as ex post facto criminal legislation. It has been laid down that no person shall be convicted of an offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor he be subjected to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offence. Under the provision, when the legislature declares an act to be an offence or provides a penalty for an offence, it cannot make the law retrospective so as to affect the persons who have committed such acts prior to the commencement of the law. Another provision under Article 20 is about prohibition against double jeopardy. Clause 2 lays down that no person shall be prosecuted and punished for the same offence more than once. Article 22 incorporates the protection against arrest and detention. Under Clause 1, no person who is arrested shall be detained in custody without being informed of the grounds of such arrest, nor shall be denied the right to consult or to be defended by a legal practitioner of his choice. The second clause further provides that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest and to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Chapter 5 of the Code of Criminal Procedure 1973 is the provision for arrest of persons. Section 41B lays down the procedure of arrest and duties of the police officer making the arrest. Every police officer, while making an arrest, shall bear an accurate, visible, and clear identification of his name. A memorandum of arrest shall be prepared, which shall be attested by at least one witness who is a member of the family of the person arrested, or a respectable member of the locality from where the arrest is made, and countersigned by the person arrested. The police officer making the arrest shall inform the person arrested that he has a right to have a relative or friend informed of his arrest. Under Section 49 of the Code, the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Section 50 of the Code provides the duty of the police officer to inform the arrested person of the grounds of arrest and of right to bail. Under section 55A of the Code, it shall be the duty of the person having the custody of the accused to take reasonable care of the health and safety of the accused. So the twin effect of the sections 56 and 57 of the Code is that the police officer making the arrest without warrant shall without unnecessary delay send the person arrested before a magistrate having jurisdiction in the case. And no such person shall be detained in the custody for more than 24 hours. Such arrested person shall be produced before a magistrate, and no such person shall be detained for more than 24 hours, except by an order of a magistrate. If the police officer arresting a person considers the requirement of the further detention, then he must follow the procedure laid down under section 167 of the Code, where the investigation cannot be completed within a period of 24 hours of the arrest. And the magistrate may order for further detention only when it appears that the accusation is well founded. Section 41D makes the provision giving a right to the accused when he is arrested and interrogated by the police. He shall be entitled to meet an advocate of his choice during interrogation, though not throughout the interrogation. And under section 60A of the Code, no arrest shall be made except in accordance with the provisions of the Code of Criminal Procedure or under any other law for the time being in force providing for arrests. Section 303 of the Code of Criminal Procedure lays down that any person accused of an offense before a criminal court or against whom proceedings are instituted under the Code be defended by a pleader of his choice. Such accused person has a right to file application for releasing on bail. Chapter 33 of the Code of Criminal Procedure annexes the provision as to bail. Before granting bail in cases involving non-bailable cases, the court takes into consideration such as the nature and the seriousness of the offense, likelihood of the accused fleeing from justice, tampering with prosecution evidence, circumstances which may be peculiar to the accused, the larger interest of the public, etc. We have mentioned in the constitutional provision under Article 20 that no person shall be prosecuted or punished for the same offense more than once. So also a corresponding provision has been enacted under section 300 of the Code of Criminal Procedure that person once convicted or acquitted not to be tried for the same offense. It has been clarified that the dismissal of a complaint or the discharge of the accused is not an acquittal. Further, in any criminal proceeding against an accused person, section 315 of the Code declares that an accused person is a competent witness for his defense and may give evidence on oath in disproof of the charges made against him or any person charged together with him in the same trial. He shall not be called as a witness except on his own request in writing. The implication of the section is that no court can compel the accused to give evidence unless he has made a request in writing. Under section 316 of the Code, no influence by means of any promise or threat or otherwise shall be used to an accused person to induce him to disclose or withhold any matter within his knowledge. Under section 24 of the Evidence Act, a confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise having reference to a charge against the accused person, proceeding from a person in authority, and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. Under section 25 of the Act, no confession made to a police officer shall be proved against the person accused of any offense. Further, under section 26 of the Evidence Act, no confession made by any person whilst he is in the custody of a police officer shall prove against such person unless it is made in the immediate presence of a magistrate. However, section 27 of the Evidence Act lays down the condition as to how much of the information received from the accused may be proved. Friends, let us conclude by mentioning that the persons accused of offences are also entitled to human rights that are permissible as the situation permits. Law presumes their innocence till guilt is established against them. It is also another cardinal principle of administering criminal justice that it is better to acquit 100 criminals than to convict an innocent person. Generally, prosecution is to prove beyond reasonable doubts in every criminal prosecution. However, by means of recent criminal law amendment acts, certain presumptions are enacted against the accused persons of their being guilty. Under section 113B of the Act, a presumption is enacted regarding dowry that in case a woman dies and it is shown that soon before her death, some person subjected her to cruelty or harassment in connection with demand of dowry. The court shall presume that such person has caused the dowry death. These are some of the exceptions to the presumption of innocence of the accused persons. Otherwise, various rights that are enacted under the national, international, and domestic laws provide for protection of the accused from arbitrary arrest and detention. So friends, this much for today. Thank you very much.